Searches and Seizures. Rule 126. Nature of a search warrant. A search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Section 1, Rule 126, Rules of Court. A search warrant is not a criminal action, nor does it represent a commencement of a criminal prosecution, even if it is entitled like a criminal action. It is not a proceeding against a person, but is solely for the discovery and to get possession of personal property. It is a special and peculiar remedy, drastic in nature, and made necessary because of public necessity. It resembles in some respects with what is commonly known as John Doe proceedings. So that was in the case of United Laboratories versus ISIP. An application for a search warrant is not a criminal action. Hence, any aggrieved party may question an order quashing the same without need for the conformity of the public prosecutor. The rule in Section 5, Rule 10 of the Rules of Court that criminal actions shall be prosecuted under the direction and control of the public prosecutor does not apply. That's in the case of World Wide Web Corporation versus People. Rule against unreasonable searches and seizures is a protection against governmental intrusion. The rule against unreasonable searches and seizures does not extend to acts committed by private individuals and entities. This rule is illustrated in one case in which the inspection team of an electric company conducted a routine inspection of several houses to check on illegal connections, meter, tampering, seals, conduit pipes, jumpers, wiring connections, and meter installations. One of the houses inspected was that of the plaintiff, who claimed that there was nothing routine or proper at all with what the inspection team did. The team, it was alleged, entered his house and the surrounding premises without his permission and over the objection of his maids. The members of the team threatened, forced, or coerced their way into his house. The plaintiff's main argument consisted on an alleged violation by the inspection team of his constitutional right against unreasonable searches and seizures. The court did not agree with the posturings of the plaintiff and declared that the constitutional guarantee against unlawful searches and seizures is intended as a restraint against the government and its agents tasked with law enforcement. It is to be invoked only to ensure freedom from arbitrary and unreasonable exercise of state power. Again, the court did not agree with the posturings of the plaintiff and declared that the constitutional guarantee against unlawful searches and seizures is intended as a restraint against the government and its agents tasked with lawful enforcement. It is to be invoked only to ensure freedom from arbitrary and unreasonable exercise of state power. That is in the case of Sebreno versus Court of Appeals. Like an arrest, the laws and rules governing a search warrant is based upon constitutional guarantees. The pertinent constitutional provision provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Section 2, Article 3, 1987 Constitution. As a rule, the Constitution mandates that a search and seizure must be carried out through or on the strength of a judicial warrant predicated upon the existence of probable cause. In the absence of such warrant, the search and seizure become unreasonable. That's in the case of Comerciante versus People. The following provision solidifies the constitutional prohibition against unreasonable searches and seizures by providing for an exclusionary rule. Thus, any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. That's Section 3, Article 3, 1987 Constitution. Arrest distinguished from search and seizure. The rules on arrest are concerned with the seizure of a person, so he may be made to answer for the commission of an offense. It involves the taking of a person into custody. A search is concerned with the seizure of personal property, subject of the offense. Stolen or embezzled property, fruits of the offense, or those intended to be used to commit an offense. A probable cause to arrest does not necessarily involve a probable cause to search, and vice versa. Probable cause to arrest involves a different determination from probable cause to search. In order to determine probable cause to arrest, the judge, not the prosecutor, must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Probable cause to search requires facts to show that particular things connected with a crime are found in a specific location. An arrest with a warrant may be made on any day and at any time of the day or night. A search warrant is generally served in the daytime, unless there be a direction in the warrant that it may be served at any time of the day or night, as provided in Section 9, Rule 126 of Rules of Court. The issuance of a warrant of arrest presupposes the existence of a pending criminal case that gave rise to the warrant. A search warrant does not require the existence of a criminal case. It may be issued prior to the filing of the case. Application for a search warrant. Where to file? As a rule, an application for a search warrant shall be filed before any court within whose territorial jurisdiction a crime was committed. There are exceptions to the above general rule. These are: A. The application may be made before any court within the judicial region where the crime was committed if the place of the commission of the crime is known. B. The application may also be filed before any court within the judicial region where the warrant shall be enforced. In both exceptions, filing in such courts requires compelling reasons stated in the application. The rule requiring a statement of compelling reasons is of a mandatory nature. Case yun ng Philippine Shell Petroleum Corporation versus Romars International Gases Corporation. Another exception, C. The application shall be made only in the court where the criminal action is pending, if the criminal action has already been filed. Ex parte application for a search warrant. An application for a search warrant is heard ex parte. It is neither a trial nor a part of the trial. Action on these applications must be expedited, for time is of the essence. Great reliance has to be accorded by the judge to the testimonies under oath of the complainant and the witnesses. This is in the case of Santos versus Price Gases. Search warrants involving heinous crimes and others. The above rules in Section 2 of Rule 126 of the Rules of Court have been deemed modified by AM number 99-20-09-SC dated January 25, 2000. In cases involving heinous crimes, illegal gambling, dangerous drugs, and illegal possession of firearms. Under the aforementioned issuance by the Supreme Court, the following are authorized to act on all applications for search warrants involving any of above crimes. The Executive Judge and Vice Executive Judges of Regional Trial Courts of Manila and Quezon City filed by the Philippine National Police, the National Bureau of Investigation, the Presidential Anti-Organized Crime Task Force, and the Reaction Against Crime Task Force with the Regional Trial Courts of Manila and Quezon City. The applications shall be personally endorsed by the heads of said agencies, for the search of places to be particularly described therein, and the seizure of property or things as prescribed in the rules of court, and to issue the warrants of arrest, if justified, which may be served in places outside the territorial jurisdiction of said courts. The authorized judges shall keep a special docket book listing the details of the applications and the results of the searches and seizures made pursuant to the warrants issued. In Marimla versus People, the petitioners filed a motion to quash the search warrant and to suppress the evidence illegally seized. It was contended, among others, that the application for search warrant was filed and the warrant was issued by the RTC of Manila, which is a court outside the territorial jurisdiction and judicial region of the courts of Angeles City and Porac, Pampanga, where the alleged crime was committed. It was also argued that the application for search warrant was not personally endorsed by the head of the NBI as required by the new guidelines. The Supreme Court observed that the cases against petitioners involved a violation of the Dangerous Drugs Law of 1972. As such, the application for search warrant may be filed by the NBI in the City of Manila, and the warrant issued may be served outside of Manila pursuant to the guidelines. The court likewise held that as to the claim that the application for the warrant was defective for not having been personally endorsed by the head of the NBI, nothing in the rule prohibits the head of the NBI and of the other law enforcement agencies mentioned from delegating their ministerial duty of endorsing the application to their assistant heads. Besides, under Section 31, Chapter 6, Book 4 of the Administrative Code of 1987, an assistant head or other subordinate in every bureau may perform such duties as may be specified by their superior or head, as long as it is not inconsistent with law. Property subject of a search warrant. The property subject of a search warrant is personal property, not real property. A search warrant may be issued not only for the search but also for the seizure of the following: A. Personal property subject of the offense. B. Personal property stolen or embezzled and other proceeds or fruits of the offense. Or C. Personal property used or intended to be used as a means of committing an offense. See Section 3, Rule 126 of Rules of Court. The rule is only the personal properties described in the search warrant may be seized by the authorities. In People v. Nunez, Search Warrant Number 42 specifically authorized the taking of methamphetamine hydrochloride or shabu and paraphernalia only by the principle of ejus dem generis. The court explained, where a statute describes things of a particular class or kind accompanied by words of a generic character, the generic word will usually be limited to things of a similar nature with those particularly enumerated, unless there be something in the context of the statement which would repel such inference. Certainly, the lady's wallet, cash, grinder, camera, component, speakers, electric planer, jigsaw, electric tester, saws, hammer, drill, and bolo were not encompassed by the word paraphernalia, as they bear no relation to the use of manufacture of drugs. In seizing the said items, then, the police officers exercised their own discretion and determined for themselves which items in appellant's residence they believed were proceeds of the crime, or means of committing the offense. This said, the court, is absolutely impermissible. In the same case, the court declared that the purpose of the constitutional requirement that the articles to be seized be particularly described in the warrant is to limit the things to be taken to those and only those particularly described in the search warrant, to leave the officers of the law with no discretion regarding what articles they should seize. A search warrant is not a sweeping authority empowering a raiding party to undertake a fishing expedition to confiscate any and all kinds of evidence or particles relating to a crime. Accordingly, the objects taken which were not specified in the search warrant should be restored to appellant. Requisites for the issuance of a search warrant. The validity of a search warrant rests on the following factors. A. It must be issued upon probable cause. B. The probable cause must be determined by the judge himself and not by the applicant or any other person. C. In the determination of probable cause, the judge must examine under oath or affirmation the complainant and such witnesses he may produce. And D. The warrant issued must particularly describe the place to be searched and persons or things to be seized. The absence of the requisites for a search warrant's validity will cause its downright nullification. In one case of a relatively recent vintage, the appeal of the conviction essentially rested on the claim that the search warrant was defective because there was no transcript of stenographic notes of the proceedings in which the issuing judge had allegedly propounded the required searching questions and answers in order to determine the existence of probable cause. The court ruled that the failure to attach to the records the depositions of the complainant and his witnesses or the transcript of the judge's examination, though contrary to the rules, does not by itself nullify the warrant. The requirement to attach is merely a procedural rule and not a component of the right. Rules of procedure or statutory requirements, however salutary they may be, cannot provide new constitutional requirements. Instead, what the Constitution requires is for the judge to conduct an examination under oath or affirmation of the complainant and the witnesses he may produce, after which he determines the existence of probable cause for the issuance of the warrant. That's the case of Ogayon versus People. Probable cause in search warrants. A core requisite before a warrant shall validly issue is the existence of a probable cause, meaning the existence of such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place to be searched. Again, Probable cause in search warrants means that the existence of such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place to be searched. Again, the existence of such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the objects sought in connection with the offense are in the place to be searched. That was laid down by the Supreme Court in Century Chinese Medicine Company versus Corporation versus People. There is no exact test for the determination of probable cause in the issuance of search warrants. It is a matter wholly dependent on the finding of trial judges in the process of exercising their judicial function. They determine probable cause based on evidence showing that more likely than not, a crime has been committed and that it was committed by the offender. One case declared in no uncertain terms that probable cause is a flexible common sense standard. It merely requires that the facts available to the officer would warrant a man of reasonable caution and belief that certain items may be contraband or stolen property or useful as evidence of a crime. It does not require proof that such belief be correct or more likely than true. A practical, non-traditional probability that incriminating evidence is involved is all that is required. Occasion. The determination of probable cause does not call for the application of rules and standards of proof that a judgment of conviction requires after trial on the merits. As implied by the words themselves, probable cause is concerned with probability, not absolute or even moral certainty. The prosecution need not present at this stage proof beyond reasonable doubt. The standards of judgment are those of a reasonably prudent man, not the exacting calibrations of a judge after a full-blown trial. Again, that's from Century Chinese Medicine Company versus People. In a case, the trial court issued a search warrant, but it later retracted from its earlier finding of probable cause, because the seized items were accordingly incomplete or insufficient to charge petitioner with a criminal offense. The retraction negated the court's previous determination of probable cause. The court disagreed because in quashing the search warrant, it would appear that the trial court had raised the standard of probable cause to whether there was sufficient cause to hold petitioner for trial. In so doing, the trial court committed grave abuse of discretion. According respect to findings of probable cause of trial courts. When a finding of probable cause for the issuance of search warrant is made by a trial judge, the finding is accorded respect by reviewing courts. It is presumed that a judicial function has been regularly performed, absent a showing to the contrary. A magistrate's determination of probable cause for the issuance of search warrant is paid great deference by a reviewing court, as long as there was substantial basis for that determination. Substantial basis means that the questions of the examining judge brought out such facts and circumstances as would lead a reasonably discreet and prudent man to believe that an offense has been committed and the objects in connection with the offense sought to be seized are in place sought to be searched. That's World Wide Web Corporation vs. People. How the examination shall be conducted by the judge. Aside from the requirements mandated by Section 4 of Rule 126, the rule requires the judge to comply with a specific procedure in the conduct of the examination of the complainant and the witnesses he may produce. The required procedure involves the following. A. The examination must be personally conducted by the judge. B. The examination must be in the form of searching questions and answers. C. The complainant and the witnesses shall be examined on those facts personally known to them. D. The statements must be in writing and under oath. And E. The sworn statements of the complainant and the witnesses, together with the affidavits submitted, shall be attached to the record. See Section 5, Rule 126. Personal knowledge of the complainant and the witnesses. The facts and circumstances to be testified to by the complainant and the witnesses he may produce, being referred thereto, pertain to facts, data, or information personally known to the applicant and the witnesses he may present. The applicant or his witnesses must have personal knowledge of the circumstances surrounding the commission of the offense being complained of. Reliable information is insufficient. Mere affidavits are not enough, and the judge must depose in writing the complainant and his witnesses. As in the case of Yao Sr. versus People. This is because the purpose thereof is to convince the magistrate of the existence of probable cause. Search warrants are not issued on loose, vague, or doubtful basis of fact, and also not on mere suspicion and belief. As in Uy versus Bureau of International Revenue. When the law speaks of facts, the reference is to facts, data, or information personally known to the applicant and the witnesses he may present. Absent the element of personal knowledge by the applicant or his witnesses of the fact upon which the issuance of a search warrant may be justified, the warrant is not deemed based on probable cause and is a nullity, its issuance being in legal contemplation, arbitrary. As in the case of Century Chinese Medicine versus People. The searching questions propounded to the applicant and the witnesses depend largely on the discretion of the judge. Although there is no hard and fast rule governing how a judge should conduct his investigation, it is axiomatic that the examination must be probing and exhaustive, not merely routinary, general, peripheral, perfunctory, or pro forma. The judge must not simply rehash the contents of the affidavit, but must make his own inquiry on the intent and justification of the application. That's from Yao Sr. vs. People. Particular description of place or person. The long-standing rule is that a description of the place to be searched is sufficient if the officer, with the warrant, can and reasonable effort ascertain and identify the place intended and distinguish it from other places in the community. Any designation or description that points out the place to the exclusion of all others and on inquiry leads the officers unerringly to it satisfies the constitutional requirement. Moreover, in the determination of whether a search warrant describes the premises to be searched with sufficient particularity, it has been held that the executing officer's prior knowledge as to the place intended in the warrant is relevant. This would seem to be especially true where the executing officer is the affiant on whose affidavit the warrant had been issued, and when he knows that the judge who issued the warrant intended the compound described in the affidavit. Yao Sr. vs. People ulit yun. Nowhere in Section 4 Rule 126 or any other provision of the revised Rules of Criminal Procedure is it required that the search warrant must name the person who occupies the described premises. The search warrant is issued for the search of a specifically described premises only and not for the search of a person. The failure to name the owner or occupant of the property in the affidavit and search warrant does not invalidate the warrant. where the name of the owner of the premises sought to be searched is incorrectly inserted, it is not a fatal defect if the legal description of the premises is otherwise correct, that no discretion is left to the officer making the search as to the place to be searched. That's in Kelnan versus People. In Uy versus Bureau of Internal Revenue, the caption of search warrant A-1 indicates the address of the petitioner as Hernan Cortes Street, Cebu City, while the body of the same warrant states the address as Hernan Cortes Street, Mandaue City. The court did not consider the discrepancy as sufficient to consider the warrant constitutionally infirm. It was not shown that there was a street with the same name in Cebu City, nor was it established that the officers enforcing the warrant had difficulty locating the premises of the petitioner. Uy explained that a description of the place to be searched is sufficient if the officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. Again, we explained that a description of the place to be searched is sufficient if the officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. Any designation or description known to the locality that points out to the place to the exclusion of all others and on inquiry leads the officers unerringly to it satisfies the constitutional requirement. A John Doe warrant, which does not name the person subject of the same, is the exception rather than the rule. Hence, in one case, a warrant was voided to the extent that it was issued against 50 John Does, none of which could be identified by the witnesses. That's in Pangandaman versus Cesar. The police, on the other hand, should not be hindered in the performance of their duties by superficial adherence to technicality or far-fetched judicial interference. While the rule requires it necessary to express the name or give some description of a party subject of a warrant, the principle does not prevent the issue and service of a warrant against a party whose name is unknown. In such a case, the best possible description of the person is to be given in the warrant, but it must be sufficient to indicate clearly on whom it is to be served by stating his occupation, his personal appearance and peculiarities, the place of his residence, or other circumstances by which he can be identified. The description must be sufficient to indicate clearly the proper person upon whom the warrant is to be served. Thus, in the early case of People versus Veloso, the search warrant stated that John Doe had gambling apparatus in his possession in the building occupied by him at number 124 Calle Arzobispo, City of Manila, and as this John Doe was Jose Maria Veloso, the manager of the club, the police could identify John Doe. Further, the affidavit of the search warrant and the search warrant itself described the building to be searched, and the description was a sufficient designation of the premises. Particular description of the items to be seized. General warrants. The Philippine Supreme Court declares that the purpose of the rule requiring a particular description of the things to be searched is to limit the things to be seized to those described in the search warrant and to leave the officers of the law no discretion regarding what articles they shall seize, so abuses may not be committed. Warrants which do not describe the things to be seized with the required particularity have been traditionally called general warrants. It has been defined by the Supreme Court thus: a general warrant is defined as a search or arrest warrant that is not particular as to the person to be arrested or the property to be seized. It is one that allows the seizure of one thing under a warrant describing another and gives the officer executing the warrant the discretion over which items to take. Such discretion is abhorrent, as it makes the person against whom the warrant is issued vulnerable to abuses. That's from World Wide Web Corporation versus People. A search warrant need not describe the items to be seized in precise and minute detail. The warrant is valid when it enables the police officers to readily identify the properties to be seized and leaves them with no discretion regarding the articles to be seized. A search warrant shall be valid for 10 days from its date. Thereafter it shall be void. Section 10, Rule 126, Rules of Court. Time of making the search. The warrant shall be served in the daytime, and such fact must be so directed in the warrant. However, if the affidavit asserts that the property is on the person or in the place ordered to be searched, the warrant may insert a direction that it may be served at any time of the day or night. Section 9, Rule 126, Rules of Court. The rule on issuance of search warrants allows for the exercise of judicial discretion in fixing the time within which the warrant may be served, subject to the statutory requirement fixing the maximum time for the execution of a warrant. People versus Court of Appeals yun. Manner of making the search. The search shall be made in the presence of the lawful occupant of the house, room, or any other premises, or any member of the lawful occupant's family. In the absence of the latter, the search shall be made in the presence of two witnesses of sufficient age and discretion residing in the same locality. The rule in this regard is clear. No search shall be made except in the presence of the persons mentioned in the rules. See Section 8, Rule 126, Rules of Court. In Panuncio versus People, the petitioner assailed the validity of the search which was allegedly conducted while she was not in the house. The petitioner alleges that since the search warrant was defective, the items seized during the search could not be used in evidence against her. The court categorically ruled that even assuming that the petitioner or any lawful occupant of the house was not present when the search was conducted, the search was done in the presence of at least two witnesses of sufficient age and discretion residing in the same locality. Clearly, the requirement of Section 8, Rule 126 of the Rules of Court were complied with by the police authorities who conducted the search. Section 8, Rule 126 of the Rules of Court provides, search of house, room, or premises to be made in presence of two witnesses. No search of a house, room, or any other premises shall be made except in the presence of the lawful occupant thereof or any member of his family, or in the absence of the latter, two witnesses of sufficient age and discretion residing in the same locality. The officer seizing the property must give a detailed receipt for the same to the lawful occupant of the premises in whose presence the search and seizure were made, or in the absence of such occupant, must in the presence of at least two witnesses of sufficient age and discretion residing in the same locality, leave a receipt in the place in which he found the seized property. Section 11, Rule 126. Next. Rule if the officer is refused admittance. The officer may break open any outer or inner door or window of a house, or any part of a house, or anything therein provided the following requisites are complied with. A. The officer gives notice of his purpose and authority. B. He is refused admittance to the place of directed search despite the notice. And C. The purpose of breaking is to execute the warrant or to liberate himself or any person lawfully aiding him when unlawfully detained therein. That's in Section 7, Rule 126, Rules of Court. Next, duties of the officer after the search and seizure, delivery, and inventory. An officer making a search has certain duties. A. He must forthwith deliver the property seized to the judge who issued the warrant. B. He must, together with the delivery of the property, also deliver a true inventory of the property seized. Such inventory must be duly verified under oath. Section 12 yun. And C. Note, a violation of the above rules shall constitute contempt of court. Next, duty of the judge, return and other proceedings. Under Section 12B of Rule 126, the judge issuing the search warrant has the following duties. A. The judge shall ascertain if the return has been made. He shall do so 10 days after issuance of the search warrant. If no return has been made, the judge shall summon the person to whom the warrant was issued and require him to explain why no return was made. C. If the return has been made, the judge shall ascertain whether Section 11 of Rule 126, the giving of receipt for the property seized, was complied with, and shall require that the property seized be delivered to him. The judge shall also see to it that subsection A of Section 12 of Rule 126, delivery of the property seized and true inventory, has been complied with. A judge should know that his duty as a magistrate does not end when the warrant is issued. When the evidence shows that the judge who issued the search warrant did not require the officers executing the warrant to make an accurate and complete inventory of the things seized and submit the same to him, he is guilty of gross ignorance of the law. Betoy versus Coliflores yun. Next, duty of the custodian of the logbook. The return on the search warrant shall be filed and kept by the custodian of the logbook on search warrants, who shall enter therein the date of the return, the result, and other actions of the judge. Section 12, Rule 126. A violation of the above rules shall constitute contempt of court. Same. Next, objection to issuance or service of a warrant. Any objection concerning the issuance or service of a warrant or a procedure in the acquisition by the court of jurisdiction over the person of the accused must be made before he enters his plea. Otherwise, the objection is deemed waived. Again, any objection concerning the issuance or service of a warrant or a procedure in the acquisition by the court of jurisdiction over the person of the accused must be made before he enters his plea. Otherwise, the objection is deemed waived. Benaventura versus People. Next, where to file a motion to quash a search warrant or to suppress evidence. A motion to quash a search warrant and or to suppress evidence obtained by virtue of the warrant may be filed and acted upon only by the court where the action has been instituted. See Section 14, Rule 126. Again, take note that a motion to quash a search warrant and or to suppress evidence obtained by virtue of the warrant may be filed and acted upon only by the court where the action has been instituted. If no criminal action has been constituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and the criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. That's in section 14, rule 1 to 6. Again, if no criminal action has been instituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and the criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. Next, who may assail the issuance of a search warrant? Well settled is the rule that the legality of a seizure can be contested only by the party whose rights have been impaired thereby, and the objection to an unlawful search and seizure is purely personal and cannot be availed of by third parties. That's from Santos versus Price cases. The manager of an establishment is a real party in interest to seek the quashal of the search warrant for the obvious reason that the search warrant, in which the manager was solely named as respondent, was directed against the premises and articles over which he had control and supervision. The manager, who is the same time the petitioner, was directly prejudiced or injured by the seizure of the gas tanks because petitioner was directly accountable as manager to the purported owner of the seized items. When the application for the search warrant averred that petitioner had in his possession and control the items subject to an alleged criminal offense, the interest of the manager petitioner becomes obvious. The corporation does not have the exclusive right to question the seizure of items belonging to the corporation on the ground that the latter has a personality distinct from the officers and shareholders of the corporation. Assuming arguendo that the corporation was the owner of the seized items, petitioner as its manager had the authority to question the seizure of the items belonging to the corporation. Unlike natural persons, corporation may perform physical actions only through properly delegated individuals, namely their officers and or agents. That's in Santos versus Price gases. A search warrant is obtained not by filing of a complaint or an information, but by the filing of an application therefore. Clearly then, an application for a search warrant is not a criminal action. The Supreme Court sustained the Court of Appeals ruling that the conformity of the public prosecutor is not necessary before an aggrieved party moves for a consideration of an order granting a motion to quash search warrants. That's in World Wide Web Corporation versus People. As a general rule, the procurement of a warrant is required before a law enforcer can validly search or seize the person, house, papers, or effects of any individual. Otherwise, such search and seizure becomes unreasonable. To underscore the significance, the law attaches the fundamental right of an individual against unreasonable searches and seizures. The Constitution clearly declares in Section 3 of Article 3 that any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. It has always been recognized that the rule requiring a warrant is not, however, absolute. There are well-recognized instances where searches and seizures are allowed even without a valid warrant under any of the following circumstances. A. Warrantless search incidental to a lawful arrest. B. Seizure of evidence in plain view. C. Search of a moving vehicle. D. Consented warrantless search. E. Customs search. F. Stop and frisk or Terry searches. G. Exigent and emergency circumstances. H. Search of vessels and aircraft. I. Inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. Again, there are well-recognized instances where searches and seizures are allowed even without a valid warrant under any of the following circumstances. A. Warrantless search incidental to a lawful arrest. B. Seizure of evidence in plain view. C. Search of a moving vehicle. D. Consented warrantless search. E. Customs search. F. Stop and frisk or Terry searches. G. Exigent and emergency circumstances. H. Search of vessels and aircraft. I. Inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. Search incident to a lawful arrest. A person lawfully arrested may be searched without a search warrant for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense. That's in People vs. Modial. The search incident to a lawful arrest exception is authorized by Section 13, Rule 126 of the Rules of Court, which provides, a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. The purpose of allowing a warrantless search and seizure incident to a lawful arrest is to protect the arresting officer from being harmed by the person arrested, who might be armed with a concealed weapon, and to prevent the latter from destroying evidence within reach. It is therefore a reasonable exercise of the state's police power, 1. To protect law enforcers from the injury that may be inflicted on them by a person they have lawfully arrested, and to prevent 2. Evidence from being destroyed by the arrestee. It seeks to ensure the safety of the arresting officers and the integrity of the evidence under the control and within the reach of the arrestee. People vs. Kalanchaw. The application of the above rule presupposes that the person searched was previously arrested lawfully. Hence, a person illegally arrested cannot be validly searched without a warrant under this provision. For an arrest to be lawful, the arrest may either be by virtue of a warrant lawfully procured or by virtue of a warrantless arrest authorized under Section 5 of Rule 113 of the Rules of Court and other applicable provisions such as Section 13 of the same rule. Consequently, where there is no lawful arrest, the drugs purportedly seized from appellant is rendered inadmissible in evidence for being the proverbial fruit of the poisonous tree. Where the confiscated shabu is the very corpus delicti of the crime charged, appellant must be acquitted and exonerated from all criminal liability. People vs. Villarreal. Stated in another way, there must be a valid search and seizure pursuant to an equally valid arrest, which must precede the search. For this purpose, the law requires that there be first a lawful arrest before a search can be made. The process cannot be reversed. Parameters of a search incident to a lawful arrest, immediate reach, and control rule. Section 13 of Rule 126 specifically enumerates the allowable scope of a search incident to a lawful arrest. The provision limits the search to the following: A. For dangerous weapons. B. For anything which may have been used in the commission of an offense. Or C. For anything which constitutes proof in the commission of an offense. The above provision also implies that the search and the seizure incident to a lawful arrest is not limited to things related to the reason for the arrest. If, for instance, a person is legally arrested for illegal possession of drugs, the search is not confined to things used in the commission of the said crime. To protect the arresting officer, the search extends to weapons like a gun or a knife with no actual connection to the crime of illegal possession of the drugs. If in the course of the search, evidence is found constituting proof of another offense, like an illegally possessed weapon, the tenor of the rule, as stated, does not prevent the seizure of the evidence. Is the search confined to the search of person lawfully arrested? How about the search of the premises where he was arrested? The phraseology of Section 13 of Rule 126 at first glance suggests that it is only the person fully arrested who is to be searched. The provision partly reads, "A person lawfully arrested may be searched." The court has, however, ruled on several occasions that when an arrest is made, it is reasonable for the arresting officer to search the person arrested in order to remove any weapon that the latter might use in order to resist arrest or effect his escape. Otherwise, the officer's safety might well be endangered, and the arrest itself frustrated. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction. Moreover, in lawful arrests, it becomes both the duty and the right of the arresting officer to conduct a warrantless search not only on the person of the suspect but also within the permissible area within the latter's reach. A valid arrest allows the seizure of evidence or dangerous weapons either on the person of the one arrested or within the area of his immediate control. The phrase "within the area of his immediate control" means the area from within which he might gain possession of a weapon or destructible evidence. A gun on a table or in the drawer in front of the person arrested can be as dangerous to the arresting officer as one concealed in the clothing of the person arrested. Valeroso vs. Court of Appeals yun. Thus, when the person arrested had his hands tied, a cabinet which is locked and found in an area different from where he was being detained could no longer be considered as part of an area within his immediate control, because there was no way for him to take any weapon or to destroy any evidence that could be used against him. Hence, the evidence seized and taken from the cabinet could not be used against him. Valeroso vs. Court of Appeals yun. Espano vs. Court of Appeals is one of the cases which derives home the point on the concept of search incident to a lawful arrest. Here, police officers arrested the accused in flagrante delicto, selling marijuana in a street corner. The search of his person yielded 2 cellophane bags of marijuana. When asked if he had more, he admitted he had marijuana in his house. The policeman then proceeded to the house of the accused and made a search which yielded 10 more cellophane tea bags of marijuana. The court held that the articles seized from the accused during his arrest were valid under the doctrine of a search made incidental to a lawful arrest. The search may extend beyond the person of the person arrested to include the premises or surroundings under his immediate control. The warrantless search, however, of the house of the accused, which yielded marijuana, became unlawful since the police officers were not armed with a search warrant at the time. Moreover, the house of the accused was beyond his reach and control. Espano vs. Court of Appeals yun. Earlier, in People vs. Lua, a similar pronouncement was made by the court. The accused in Lua was arrested outside his house in flagrante delicto in a buy-bust operation. The court found nothing objectionable in the body search of the person arrested and the confiscation of the bags of marijuana and the Paltic revolver in his person. However, the subsequent research of the house of the arrestee was found invalid and the marijuana found therein considered inadmissible. The search of the house, according to the court, is not within the contemplation of a search incident to a lawful arrest. The house at the time of his arrest was not within the reach and control of the arrestee. People vs. Lewin. Automobiles, declared the court, unlike a store, dwelling, house, or other structure, are readily mobile, and it is not practicable to secure a warrant because the vehicle can quickly move out of the locality or jurisdiction in which the warrant must be sought. The ruling, however, did not authorize officers to stop every car on the road on the chance that they might find contraband. To undertake a warrantless search and seizure of a car, officer had to possess probable cause. The Carroll Doctrine was re-echoed by the Philippine Supreme Court, which similarly ruled that warrantless search of a moving vehicle is justified on the ground that it is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. That's in People vs. Tuazon. The Supreme Court of the Philippines, in one case, wrote, "This exception is easy to understand. A search warrant may readily be obtained when the search is made in a store, dwelling, house, or other immobile structure. But it is impracticable to obtain a warrant when the search is conducted on a mobile ship, on an aircraft, or in other motor vehicles, since they can quickly be moved out of the locality or jurisdiction where the warrant must be sought." That's in People vs. Mariacos.